Welcome to SA Labor Help. In this discussion, we will shortly touch on the process of suspending an employee from duty and requiring the employee to attend a disciplinary hearing. We will shortly deal with when to suspend an employee and when not to. Secondly, we will deal with the essential elements of the notice to appear at a disciplinary hearing. Suspension of employees is common in the workplace. This means employers should be aware of the correct processes and procedures which must be complied with when suspending an employee. There exists two forms of suspensions, namely precautionary suspension and punitive suspension. Fairness dictates that employers must follow a process prior subjecting an employee through a disciplinary hearing. This is in line with, and codified in, the Labor Relations Act 66 of 1995, Schedule 8 thereof the Code of Good Practice, Dismissal. Specifically, Item 4 gives employers guidance and requires an employer to conduct an investigation prior to taking disciplinary action against an employee. Depending on the type of the alleged misconduct, the employee's position with the employer, and the circumstances surrounding the investigation, employers have discretion to suspend an employee during the investigation process. This is called precautionary suspension. The purpose of a precautionary suspension is to ensure that an employee's presence at the workplace does not obstruct the investigation and/or that the employee does not interfere with the gathering of evidence. The ideal is that an employee should only be suspended when there is a reasonable objective perception that an employee did commit the alleged misconduct and that the employee should, as a result, be excluded from the workplace. The Labor Court holds a very strong view on suspension and the effect thereof. In the case of Margothel v. Premier of the North West Province and another, the Labor Court stated that the suspension of an employee pending an inquiry into alleged misconduct is equivalent to an arrest and should therefore be used only when there is a reasonable apprehension that the employee will interfere with investigations or pose a threat of some kind. It is vital to note that whilst an employee is suspended as a precautionary measure pending disciplinary action, the employee is still an employee and should therefore still be paid remuneration. Should an employer unilaterally decide not to remunerate an employee during precautionary suspension, the Labor Court held that the employer will be in breach of contract. A punitive suspension, on the contrary, means just that: the suspension is punitive I. It is a punishment and a sanction imposed on the employee who has already been found guilty of a misconduct or breach of a term or condition of his or her employment subsequent to a disciplinary hearing. If the employee is found guilty at a disciplinary hearing or process, in these circumstances, punitive suspension is a sanction which can or may be imposed by the employer on the employee as an alternative to dismissal. If an employee commits misconduct, the employer cannot just dismiss him. The employer needs to first hold a disciplinary hearing/inquiry. The first step in the process is that the employee needs to be informed that he or she has to attend a disciplinary inquiry, or, in other words, the employee must be given a notice to attend the disciplinary hearing. The notice to attend a disciplinary hearing consists of various elements. These elements will shortly be touched on hereunder. The notice needs to inform the employee about the following. 1. The allegations, charges, against the employee. These need to be written in a simple manner to ensure that the employee understands the allegations against him. Each charge must be specific. This means it must specify the when, where, who, and how. This will assist the employee to properly prepare his defense against the allegations. 2. The rights of the employee. The employee has certain rights that need to be highlighted in the notice. Their rights are as follows. A. To attend the inquiry. B. To be represented or assisted by a colleague or shop steward. C. To an interpreter or translator. D. To present his case, lead all relevant evidence. Thus it means that the employee will make representations in defense of the charges. E. To call witnesses in support of his defense. F. To cross-examine any person called upon as witness in support of the allegations. And G. Access to all documentation to be produced in evidence. The following essential elements must also be present on the notice: the date, time, and venue. This will ensure that the accused employee knows the date on which the inquiry will take place, the time that will take place, and where it will take place. That the misconduct may result in dismissal if proven. This will inform the employee that the misconduct is of a serious nature, and if found guilty, it may result in his dismissal. Non-attendance. This is important. It must be explained to the employee what will happen if he does not attend for whatever reason. The employee needs to be informed that if he fails or refuses to attend the inquiry and fails to timeously provide an acceptable and legitimate reason for his absence, the inquiry may be conducted in his absence and finalized without him being present. Such failure or refusal will be interpreted to imply that he has waived his right to an inquiry. Name of chairperson. It is advisable to inform the employee who will preside over the proceedings and whether it is an internal or external person. Date of the notice. It is advisable to show the date on which the notice has been formulated. This will indicate how long after the incident or misconduct has been committed, action was taken by the employer. Acknowledgement of receipt. The employee must sign receipt of the notice. It is advisable that this is done in the presence of a witness who must also sign to confirm that the notice has been handed and explained to the employee. As a recap, the employer should understand the difference between precautionary and punitive suspensions. Also, it must be understood when to apply the different forms of suspension. With regards to a notice to attend a disciplinary hearing, it must be understood what the different elements of the notice consists of and what the importance of the notice is when the employee is subjected to a disciplinary process which may lead to the employee's dismissal. Please note that with the SA Labor Help application, when you are subscribed, you will be able to, with a few pushes of buttons on your phone, draft the required disciplinary documents, such as a notice of suspension of disciplinary hearing. The application places labor law in your pocket as it is on your cell phone. The documents are generated in PDF format instantly and can be sent by the employer via email to the employee or can immediately have it printed. This application has been generated by a labor law expert whom have been practicing as a commissioner in the CCMA since 2014. Please remember that the SA Labor Help application places the South African labor law in your pocket.